Thank you very much for inviting me to this most interesting symposium where, under my subject, law and your subject will be converging. And my presentation, I don't have a PowerPoint presentation, but I have prepared a document to be distributed, which I would be using as the discussion progresses. Can you please make that available? Some lady collected there. Yes. Now, the topic given to me is to discuss on a very important subject on law, that is diminished responsibility. I must state, this defense has not taken any force in our legal structure up to now, due to the fact that no court has yet tried this as a defense, as an extenuating circumstance that would bring the culpability for murder down to manslaughter. That's number one matter that has to be understood when one comes to understand the operation of diminished responsibility. Diminished responsibility is a defense used by criminal lawyers to demonstrate that a person who is charged with murder ought not to be found guilty for murder, but to be found guilty for manslaughter, a lesser offense, due to the extenuating circumstance, that is, that he acted under a certain circumstances as described in the law that gives the definition of it. And I have now given to you the definition as found in the English law. Now, if you go through this statutory provision carefully, I'm sure you might be able to gain some understanding of what it means in law to be diminished responsibility. Let us go through that. The statute, this is the English statute, I'm drawing this from the English law. It says, as now amended, Section 2, Homicide Act 1957 provides a complete definition of diminished responsibility. The material parts of it as follows. Persons, please go through it with me, because then that would make things very clear for you to understand as to what it means by this law. It says, a person, that is D, who kills or is a party to the killing of another is not to be convicted of murder if D was suffering from an abnormality of mental functioning which A, arose from a recognized medical condition, B, substantially impaired D's ability to do one or more of the things mentioned in subsection 1A. 1A will follow. C, provides an explanation for D's acts and omissions in doing or being a party to the killing. So 1A, those things are A, to understand the nature of D's conduct, B, to form a rational judgment, C, to exercise self-control. Or the other page, 1B, for the purposes of section 1C, an abnormality of mental functioning provides an explanation for D's conduct if it causes or is a significant contributory factor in causing D to carry out that conduct. 2, on a charge of murder, it shall be for the defense to prove that the person charged is by virtue of this section not liable to be convicted of murder. You have to remember, under our common law that is practiced in Ceylon and Sri Lanka and in other countries where the English common law practices are still prevailing, on certain instances, the accused is placed on the task of proving, on a balance of probability, with preponderance of evidence, that that particular defense is acceptable and valid, and therefore he is not to be charged or convicted for the murder, for the offense for which he is charged, but for offense which is lesser than, in degree than the original charge. Murder is a classic example. Provocation, if a murder has been committed under severe provocation, that is one factor that would diminish the responsibility from one tier to the next, and the person will be found guilty for manslaughter, as you all know. And then cumulative provocation, another defense that is available in Sri Lanka. Then sudden fight where there has been a very severe sudden fight. That's also another extenuating circumstance that is available in Sri Lankan law. Alongside, you have this kind of new concepts. These are not new to many countries where the English law is now well developed, in Australia, in New Zealand, in South Africa, in England, UK, in all these countries. These defenses are oft used in courts as extenuating circumstances to prove that the gravity of the crime should be reduced. In Sri Lanka, we have not yet tested that. But the opening of the availability of the possibility for us to use this is there, because in law there is a thing called causus omissus. That means in instances where there has been a lacuna or some kind of a gap in using any kind of a particular concept of law, we could draw inspiration from the English law and adopt the English concepts into our legal system to fill up that gap. So this is one instance where the possibility for a lawyer to adopt this as a defense is still available, and this is how it should be done. And the accused, if he takes refuge under this particular concept, to make sure, to ensure that his liability is reduced from murder to manslaughter, this has to be proved by referring to the matters that I stated earlier in the statutory provisions as found in the English law. Now, this is the law as it stands now, presently, and it's been used around the world where common law is practiced. But some time back, originally, when this law was introduced, that was long years ago, the original statutory provision relating to diminished responsibility described it as, I have stated that towards the end of that page, where a person kills or is a party to the killing of another, he shall not be convicted of murder if he was suffering from such abnormality of mind, within brackets, whether arising from a condition of arrested or retarded development of mind or any inherent causes or induced by disease or injury, close brackets, as substantially impaired his mental responsibility for his acts and omissions, indeed not being party to the killing. So I would like to, before we delve into this matter more fully in a legalistic sense, for you to please read this section quietly in a minute or so, and let me know how you understand that. What do you, as psychiatrists, understand by the wordings of this statute? Can somebody please let me know how you understand it, what it means? So before you go to that extent, I will just lay down the provenance of this law. The origin of law was in Scotland. As far back as in the 19th century itself, in Scottish courts, on and off, they raised this issue and referred to this defense to show how the responsibility for murder could be reduced to manslaughter. And you know what manslaughter means. Murder, in a very layman's simple word, is killing a person intentionally. You have that vicious mind to cause the death of a person, and with that vicious mind, driven by that, you cause the death of a person by inflicting injuries to that person. That's murder. But when circumstances are different, if you do not have that intention to do that, you act in a particularly an impulsive manner. You act in a particular manner which is not, although the intention was there, but that intention was as a result of a certain circumstances that has colored your thinking process and so on. For instance, grave and sudden provocation or cumulative provocation. Cumulative provocation is in a case, I'll give you an example, like there was this case of a woman who had been resorting to infidelity, and the husband had been seeing this for years and years, and he tolerated it for a long time, but finally that came to a sort of a climax, and then he resorted to violence in a Badul area. This is a reported case in Sri Lanka, and he killed that woman. And he took up the position that this is an accumulation of a long period of provocation that has driven him to cause this death and cause her death, and the liability for murder as a result of it was reduced from murder to manslaughter. That's cumulative provocation. Now, in the same way, there are so many other defenses that are available with which you could bring the gravity of the crime down to another level. So now, if you read this section carefully, as you find in the English law, I would like you to let me know what you understand as psychiatrists as to what it is trying to convey to you from a medical perspective. I'll read it again. As now amended, forget about that. Persons suffering from diminished responsibility to a person, that is the defendant, who kills or is a party to the killing of another, is not to be convicted of murder if D was suffering from abnormality of mental functioning which A arose from a recognized medical condition. Now that is a part that has to be found out with having reference to the evidence of a psychiatrist, an expert on the subject, that there had been a prevailing medical condition that had driven the person to commit that particular offense. C, substantially impaired D's ability to do one or more of the things mentioned in subsection 1A. Subsection 1A you find towards the bottom. C, provides an explanation for these acts and omissions in doing or being a party to the killing. Then what are those things referred to in subsection B? 1A, those things are the person, the killer, he had to understand the nature of this conduct. B, to form a rational judgment. C, to exercise self-control. So that is what it means by what are those matters that substantially impaired his ability to form a rational judgment in relation to what he was doing. What are those matters? Once again, he has failed to understand the nature of his conduct and he could not form a rational judgment. And C, he has failed to exercise self-control as a result of those medical conditions prescribed earlier. Now that is the basic principle. I hope you all understand what it means by that. The plain reading of the law would make it clear what it means basically by this law which deals with diminished responsibility. The problem that came up very often in courts, very repeatedly, was to find out what it means by, as a result of this condition that existed at the time of the commission of the offense, that his conduct, that understand of his conduct and the understanding of his conduct and his ability to form a rational judgment in relation to his activities was substantially impaired. What do you mean by substantially impaired in this particular statute? That is the most important, the pivotal point as far as the understanding of the operation of the law is concerned. That is where there had been several judgments. You have to understand, unlike your science-based, more sort of experimental-based evolvement of knowledge, ours is very much based on precedent, and we rely on judicial pronouncement by several courts, higher courts, to understand how we should be interpreting this law when it comes for us to make a comprehensive, objective understanding of what the law is trying to say. Now, the question that came up repeatedly in the understanding of this concept of diminished responsibility has been what it means in the section by, as a result of this impulsive reaction of the person, this diminished responsibility, his rational behavior was substantially impaired. What do you mean by that? So there have been several cases in which it was discussed in courts in England, in Scotland, in Australia, in New Zealand, and other places, and I don't think I should go into all those cases, but in a very basic way, the structure had been described in the House of Lords in England in the following manner. In Byne, the defendant was a sexual psychopath who had strangled and mutilated. I'm soon after my eye operation, so sorry if I find it difficult to read some of these things. Mutilated a young woman, resident of the YWCA. The case on his behalf was that he was unable to resist his impulse to gross and sadistic sexual violence. The judge's direction had amounted to excluding from abnormality of mind an inability to control his urges, and this was held to have been wrong. The court further took the view that on the medical evidence, the defendant was so disturbed that there was no room for doubt that diminished responsibility was made out. Given the judgment of the court, however, Lord Parker, Chief Justice, addressed the question of substantial impairment. This is how Lord Chief Justice of England and Wales has described what substantial impairment means. Assuming that the jury are satisfied on the balance of probabilities that the accused was suffering from abnormality of mind from one of the causes specified in the parenthesis of this subsection, the crucial question nevertheless arises: was the abnormality such as substantially impaired his mental responsibility for his acts in doing or being a party to the killing? This is a question of degree and essentially one for the jury. Medical evidence is, of course, relevant, but the question involves a decision not merely as to whether there was some impairment of the mental responsibility of the accused for his act, but whether such impairment can properly be called substantial, a matter upon which juries may quite legitimately differ from doctor. So a medical scientist, a psychiatrist who would be giving evidence might say that this person has acted in a particular manner, under a particular impulse, as a result of the impairment of his mental capacity to form a rational judgment in relation to the action he was resorted to. That is a scientific opinion expressed by a person who is versed in the subject and who is called upon to give evidence on that matter. But finally, when it comes for it to be decided whether that impairment in fact had a substantial impact on the action to which he had resorted in causing the death of a person, is a factual matter that has to be left in the hands of either the judge who decides on it finally, or in the hands of the jurors, who would be the judges of facts under the system that we practice in the common law countries. So the most important thing is the doctors who are called upon, the psychiatrists who are called upon to give evidence, will have to focus their attention onto this particular important aspect of it. Here is a person who has some kind of a mental disorder. Here is a person whose mental disorder is in such a grave manner, it had an impact on his behavioral pattern, and it had an impairment of his rational, the judgment basis process, and as a result of it, he may have resorted to the violence that he resorted to in a particular case. Whether that amount of that mental inability for him to form a rational view on it, whether it was in fact an impairment that is substantially enough for the consideration of finally the judge to bring the gravity of the crime down from murder to manslaughter, is purely a matter of fact that is to be left in the hands of the judges of the case. So that's one aspect of it that has to be understood. Then, another matter, this court has repeatedly approved directions to the jury which have followed directions given in Scots cases, that is in Scotland, where the doctrine of diminished responsibility forms part of the common law. We need not repeat them. They are quoted in several cases in different areas. Both in England and in Scotland, it has subsequently been held that it is not usually helpful to direct jurors in terms of the borderline insanity. That is demonstrated by considering the case where the mental impairment is depression, to which, however severe, such a description is inapt. Such a formulation was later disproved in R versus Sear. These are cases, reported cases, and is now more often and wisely avoided even in a case of florid psychosis. Despite its use in Bryan, it cannot have been the intention of the court in that case to require any such direction, given the approval of another case which had commended abstention from elaboration of the words of the section. Now, this is important. It is to be remembered that in the case of Bryan, all the doctors agreed that Bryan could be described as partially insane. He was a sexual psychopath who had hideously mutilated a young woman he had killed. In such a case, the evidence justifies inviting a jury to determine the degree of impairment of mental responsibility by a test of partial insanity. But it is not a legitimate method of constrain an act of Parliament to substitute for the words of the Act an entirely different phrase and to say that it is to apply in all circumstances. We are sure that this was not the intention of the court in Bryan, and the phrase was used as one way of assisting the jury to determine the degree of impairment of mental responsibility in an appropriate case, and no doubt to point out that Parliament, by the use of the word substantial, was indicating a serious degree of impairment of mental responsibility. So a doctor who gives evidence on this matter will have to advert his mind to show whether the kind of mental disorder that is found in the patient has caused a serious impairment of the judgment-making process of that person for the court or the jury to form an opinion as to the degree of his liability eventually. Now, those are the most important things that has to be understood in a matter of this nature. In a case, once again, I would like to...
interrupt you, sir.
My time is up?
Yep.
All right, okay. So that's basically the structure. I'm sorry, there's a lot to be said, but, so basically for you to understand the law, what you have to do is, please go through the paper that I presented to you and try to understand what the law is trying to describe to you when they discuss about diminished responsibility. And thank you very much for giving me this opportunity once again. Thank you.